Before we get started, we wanted to thank Liberty Mutual Surety for sponsoring this episode of Let's Get Surety. Liberty Mutual Surety provides contract and commercial bonds for all size companies and contractors around the world. Liberty Mutual is here for you today, tomorrow, together. For more information on Liberty Mutual's breadth of surety products and solutions, visit www.libertymutualsurety.com. Now on to our show.
You're listening to Let's Get Surety. Let me hear your bonding talk with Kat Shamapande.
Hey everyone, it's Kat Shamapande. Thanks so much for joining us for this episode of Let's Get Surety. Got with me today my co-host, Mark McCallum, CEO of NASBP. Hey Mark, thanks for being on.
Hi Kat, I love to be here. We got a good topic.
I know you're excited about today's topic, Mark.
I am. Everybody gets into disagreements, right? You got to figure out how to solve them.
Yeah, we're going to be talking about different forms of dispute resolution and mediation. So to do that with us today, we have Steve Nelson, Executive Vice President, Senior Director, ADR Services at Markel Surety. Hey, Steve, thanks for being on.
Good morning. Thank you for having me. Glad to be here.
Good to have you on and have you here to share your many years of experience. With that said, Steve, can you tell us a little bit about yourself and how you got involved in surety?
Yeah, I call myself a recovering construction lawyer. That's what I did in a law firm practice for 20 years. And then through my wanderlust, I became a CEO of a construction company for 5. And for almost the last 25, I have been an executive with Markel Surety. Most of that time in claims. More recently, I've handed the reins off on that, and I'm a full-time mediator of other people's disputes.
Well, it seems like you've probably seen a little bit of everything during that time. So, probably good. It's a good background for somebody who wants to get into alternative dispute resolution. Would you agree with that?
Yeah. I mean, there's a need for plenty more of us because there's a lot of disputes.
Yeah. Construction is something that almost inherent that there's going to be some disagreements, perhaps even disputes on every project.
Mark, conflict in construction is absolutely predictable. I mean, you can't put that many different entities, each with a competing profit motive, each competing for space, for time, everything else. The sin is not having conflict. The sin is not preparing for it.
Well, I love that. I mean, so each project's unique, right? So you can anticipate that it's going to be unique to each party. And you made such a great point. Since you can predict that there's going to be some level of conflict, what is it that parties can do ahead of time to think about how they're going to resolve disputes that arise?
Well, not only resolve them, but avoid them in the first place. So we've all heard about the 3 C's of underwriting: character, capacity, and capital. I think if you ask any claims professional, they're going to say, gosh, I wish we'd already had a 4th C, contract terms. And in particular, those that relate to dispute avoidance and resolution. So there's a lot of things you could do. I mean, on the avoidance side, a good dispute resolution term clause is an avoidance clause in itself, because if people know with certainty what's ahead of them, they tend to behave a little bit better. They tend to resolve issues. And then as far as dispute resolution, think of this. If you get in a fight, you get in a conflict, pretty much I say black, you say white. I say let's mediate, I say let's not. And so sometimes we need a contractual term that puts us into a process, like mediation or standing neutral, something like that.
Well, and so that's really interesting. So how specific do you need to get in the contract with respect to the mechanisms that you might resolve disputes with?
Not that specific. I mean, you want to do 2 things in your contracts. One, you want to put in provisions that encourage resolution. And then you also want to make sure you don't have mismatches in your contract or contract terms that are bad for you. Let me start with the bad for you.
Sure.
Yeah, if you're a small Texas subcontractor doing work for a Texas contractor's local office on a Texas project, but your contract says you've got to arbitrate the dispute or litigate the dispute in New York City, you might want to think about that. That's going to be expensive. That's going to tilt things unnecessarily in favor of the other side. General contractors find themselves with litigation in their dispute resolution, but arbitration with subcontractors. You don't want to mismatch so you can get everybody that's necessary into the mix when you want to. And then you try to match the dispute resolution processes to the project. Huge project going to go on for years. You're going to have years worth of conflict come up. You want to put something in place, maybe a standing neutral. Think about a dispute review board, something that you can, or someone you can turn to when problems come up to help people resolve things. Mediation, those sorts of things.
Go ahead, Mark.
Go ahead. So, Steve, we keep using various terms, but what's wrong with just allowing disputes to go to litigation? Is that something people should think long and hard about?
So litigation is the default in this country. If we do absolutely nothing in our contracts, you've always got access to the courts. Okay. Our judicial system is as good as any in the world, but it has its drawbacks for our industry in that we have technical jargon, we have contractual relationships that may not be as exciting to the people who showed up for jury duty thinking they were going to get a good car for a divorce, all right? And so when we have the opportunity to select, our judge, select our triers of fact, we ought to take advantage of it. We ought to think about it. Do we want to take advantage of that? I'm not saying litigation is bad, but conscious thought about whether it's appropriate for our situation is what we need.
Well, you mentioned something. So not every judge and jury is familiar with surety and construction principles.
To top that off, you're about to go in front of 12 people who were not smart enough to get out of 6 weeks of work listening, doing consultants. How about that?
Right.
That's tough.
So you mentioned a couple words, but we haven't really kind of defined what those are. Could you kind of let us know a little bit? You mentioned arbitration, mediation, dispute review boards. Tell us a little bit about each one. How are they different? What are they? That kind of thing.
So arbitration, think of it as private judging. You pick one or three arbitrators who could be construction lawyers. They could come from a construction background. They could just be ordinary, everyday folks. Often they work under a different administrative group like AAA or JAMS or the ICC. So there are a number of our groups that actually train and sponsor arbitrators. They hear the case just like you would at the courthouse, a little less formally, a little less use of strict evidentiary issues. They make a decision. It's binding. It's final. It's not appealable usually, but a lot of contracts and for a lot of the past decades have required arbitration in our industry. We were early adopters and we're familiar with it, and it works. Mediation, on the other hand, is where you're using a neutral person to simply facilitate a resolution. So that's what I do pretty much full time now. And either a court will ask me to do something or the parties will come to me, and it could be during contract formation. It could be the middle of a contract. It could be the end. It could be something that's already in litigation or arbitration, and say, can you help us come together and resolve a dispute? I don't get to make a decision. I simply am the facilitator. They've got to do the heavy lifting. Dispute review boards are a process that came about during the Eisenhower Tunnel project, where they bored a big hole through the mountains and had all kinds of claims and said, gosh, we don't want to do this again because we got to bore the westbound route through the mountain. And so they went out and found 3 professionals, highly respected professionals, and sat them down and said, here's what our project's about. Got them familiar on the front end, had them come back every month for a meeting, and they were available to hear disputes that came up during the course of the project And even if you had a dispute resolution process at the end, what was interesting is they were like the Maytag repairmen. Nobody came to them. Everybody knew once a month we're going to have these three distinguished people that are going to decide something for us. So everybody on the project level got busy and resolved it before they got there.
Right.
So after that, Corps of Engineers and a lot of other groups of large infrastructure projects said, let's do this. And the number of claims on big dam tunneling projects dropped greatly.
One of the things that strikes me is a word jumps up to mind: autonomy. Like, what do the parties have more autonomy in one of these dispute resolution mechanisms versus another? And then the other thing, if you would comment on, is what about the costs to the various mechanisms?
Sure. So autonomy, if I understand your question, when you resort to higher authority, whether it's an arbitrator, a judge, or whatever, you take the decision-making out of your hands and put it in the hands of someone else. So any process that allows the parties to come up with their own resolution, it saves relationships. It's more lasting very often, typically more control of the outcome, usually less expense. So we're looking for processes, and all conflict kind of can be resolved in one of really four ways. You can avoid it in the first place. We try to do that through pre-qualification and good practices on the front end, through collaboration, which is, step negotiation, mediation, partnering. All of these things are collaborative processes. As you escalate, you go to resort to higher authority, meaning arbitrators or judges. And ultimately, you go to unilateral action, strikes, default terminations. If you put it in the context of world conflict, dropping a bomb.
Right. And there's probably, I imagine, different costs associated all the way up.
The more collaborative, the more avoidance costs very little. Collaboration costs very little. Higher authority, a lot more. Unilateral actions cut some grave consequences sometimes. So for example, mediation is typically a one-day event. We see it more as a process these days with a lot more planning and thought that goes into it than we did, say, 20 years ago. But it's still typically one day's fee for a mediator to help resolve a dispute. Arbitration can be more expensive on the front end, in the sense it's got fees to the arbitrators compared to the $12 a day or whatever jurors get paid. And so it can be more expensive, but it can be quicker and ultimately less expensive than litigation. So each process different. There's one that I really like that I don't see enough, but it's catching on, and that's the idea of a standing neutral. Which is the idea at the front end of the project. You just designate a trusted third party. Might be a lawyer, might be a retired construction executive, a professor, anybody, and just say, if we have a problem, we're going to them. We don't even know now if we're going to call them a mediator or we're going to have them resolve interim disputes. But we want to know now, so we're not arguing about who that's going to be in the heat of the moment. Dispute review boards are simply an advanced version with more people of a standing neutral. Easy to put in the contract. I get put it in all the time. I've yet to be called on most of them, maybe because they think, oh my goodness, Steve's going to be here, and he was to do something different.
So, they can literally give, would it be an advisory or a binding decision, or it could be either, depending on how you set it up?
Either way. You could make it advisory. You could make it binding for the remainder of the project, meaning we're at a point where we don't know if we go left or right or pay for this change order or not. And the neutral may say, we're going to pay for it now. You are going to pay this change order. You're going to go this direction. But at the end of the project, you can reserve the right to appeal that and go through whatever your dispute resolution process is in your contract.
And I imagine that you would probably specify the role there up front in the contract language. Is that correct?
Correct.
Okay. Well,
Do you have any examples from your experience, Steve, on where a resolution board like this has been in place and how that's made a big difference in the process?
Yeah, I'm currently chairing one on a large airport project, and there's an architect engineer on there. There's another lawyer and myself, and we were selected kind of mid-project. Ideally, you would do it at the front end, but as problems started to develop toward the end about closeout and such, we had an opportunity to at least give them advisory opinions. One side or the other probably appealed every single decision, but it calmed things down and it kept things moving. In a sort of a single standing neutral context, and this was not selected on the front end, but a large infrastructure project, contractor and owner absolutely at each other's throats at some point, and they said, let's bring in a neutral to see if we can't de-escalate this. So I came in, surety, contractor, owner, we kind of toned things down, no defaults declared, came up with a plan to finish, made some interim decisions to adjust some dollars here and there, and then provided that there would be a standing neutral for the rest of the project who, if we had more problems, could do things. So it worked. It was relatively inexpensive and avoided what could have been catastrophe. And I really enjoy seeing projects that are saved midstream. You know, we all know about mediating cases that have been litigating for 3 years and bringing them to conclusion, and it works. And mediation's a good process for that. But using neutral tools earlier in the project cycle can really save money and avoid conflict.
Yeah. Well, so if I'm one of those parties and I'm trying to think through ahead of time how I should resolve my disputes and talking with my legal counsel about how to map that out in the contract, what are some of the things that I should look for in a neutral, standing neutral and or a mediator? What are the important considerations should I, reflect on to pick the right one to make sure that, I feel like, they have my trust and probably the other party's trust to give that kind of opinion and maybe to resolve the dispute or allow us to resolve it because I've gotten good advice.
So that's a big question.
Yeah.
Lots of issues there. I mean, you're in a mediator, I think, and for most of the issues that we deal with, you like to find someone that's already very familiar with the construction process, very familiar with the types of disputes that come in, doesn't have to have an explanation of what a punch list is, has at least a passing knowledge of what critical path analysis would look like. So I think that speeds things along, but you're ultimately looking for someone that's got good people skills. And there's training programs out there that all of us have been through that teach us how to, help bring people together. Sometimes you can't identify that person, but you may identify an organization that maintains a stable of people with different qualifications, American Arbitration Association, GMs, ICC, and a lot of other local dispute resolution processes that do that. They're out there.
Steve, have you been in situations where things have gone wrong? And what can the right neutral do in that situation?
Mark, my life has been things have gone wrong for 50 years. That's what I've dealt with is things have gone wrong. So, I think most people would be familiar with mediation and would say litigation in its fourth year has gone wrong. We've spent a lot of money. We haven't resolved anything. We still don't know when we're going to get a resolution. And you bring somebody together to help bring it to solve it. I mean, mediation is going to solve problems 85, 90% of the times. Less than 1% of all cases that get filed in litigation in the United States go to trial. So it's not whether it eventually will settle, but mediation settles it quicker, earlier in the process, less expensively. So that process works.
Yeah, pretty impressive if the success rate is 80 to 90% going to mediation. That's incredible. And then, as you said earlier, that's something resolving a dispute probably earlier than it would be in some other form, like arbitration or litigation. So,
or even before any of those are filed, or before the job's finished, before problems have developed.
So if I'm a party that has privacy concerns, let's say it's a sensitive project, how does that play into choosing an ADR method or choosing ADR at all?
So remember, if you don't do anything, you're going to be in litigation. The courts are open to the public, absent special decisions by the judge to keep things quiet and confidential. Your competitor can sit in the courtroom and watch the trial and take notes. So litigation for those who are hypersensitive about trade secrets and patents and things, not a good idea. Arbitration is confidential. Certainly the interim process is like a neutral or a mediator or confidential. I can't reveal what happened in the cases that I resolved. And most states have laws that make that privilege and that confidentiality about as strong as any that we have in our jurisprudence.
Wow. So I'm a surety professional. I'm a producer. What role can I play in helping my client kind of think through these things?
A single question will help. What's going to happen if things go wrong? How are we, how does this contract deal with what happens if things go wrong? Or how does this contract keep things from going wrong? It's a great question. You'd be surprised, I guess, or maybe not. I'll ask lawyers in the middle of a dispute sometimes, well, what's the dispute resolution process? And they haven't gone to look at it. I teach a class in dispute resolution at the University of Texas, and I'll ask my students, who are typically engineers and contractors, I said, tell me what the dispute resolution process was in your last contract. They usually can't. They can tell me liquidated damages. They can tell me the time. They can tell me what they built. So just paying attention on the front end, asking about dispute resolution. And I'll say something else. You take a marginal submission, a marginal account, someone that's wanting to get a little bit larger bond line than maybe they otherwise would, their financial statements would support, or perhaps is about to get into a different line of work, dealing with a larger contractor or larger owner.
Right.
A good dispute resolution process would be something, if I were a producer, I would be pointing out to the underwriters and saying, here's one of the things that exists in this project that makes it a safer project. I'd also be pointing out to them that I have an account who recognizes the value of dispute avoidance and resolution and insisted this be in there if they could. We can't always pick and choose our dispute resolution processes, and talking about it on the front end is sometimes awkward. You've worked a long time to work with this private owner. You've taken them to football games. You've given them different proposals over the years. And it's hard to sit down and say, let's talk about what happens when this thing goes wrong. Nobody wants to talk about it. But I think if you talk about it, things could go wrong. Conflict is inevitable. Let's talk about it now and save that relationship.
Well, it seems like, too, it'd be, in some ways, a little bit easier to have that conversation when everyone's still friends at the beginning.
Obviously. It's still sometimes, it's a little bit of a downer, but it's a lot easier then, because everybody says, well, we're not going to have a fight. Say, what do you want to use? What process do you want to use? That's fine with me. And that's the time to get it put in place.
Well, I love your point about, if they're putting in that much thought ahead of time on how they want to resolve disputes, it's probably bodes well for that company and how prepared they are and to do their work and do their work the right way. So great indicia. Yeah, it does seem like that would be something that underwriters would find appealing for a producer to highlight when they're looking to.
I've been preaching to the underwriters that they should be anyway.
Well, that's good, Steve. One more question before we let you go. I was just wondering, over the decades of being involved in surety and claims and construction, have you seen a change in the way that these claims are being handled? I know you mentioned you're seeing more advanced discussion of this. Any other changes you've seen over time?
Yeah, remember, I started practicing law and dealing with construction disputes 50 years ago. I never practiced law with a cell phone or a computer on my desk. And back then, we tended to take standard form contracts. They were too hard to change. You needed tools for that. So we just took the contracts, nothing much. Today, contracts can be changed overnight. People can, and we've seen some weaponization of contracts, of very one-sided contracts. See weaponization of dispute resolution processes. So that's changed. Things move faster. Communications are quicker. Problems pop up. The other thing is that is with the internet and everything else, the world is we can go anywhere. 50 years ago, you were still dealing, for the most part, with people you knew and locally. The contractor in Dallas, Texas, was dealing with the owner from Dallas, Texas, whose kids both were on the same soccer team. We're dealing more with strangers because we can do it. We can travel farther. We've got the internet to figure out, the qualifications of subs in a city we've never dealt with before. So we're dealing with strangers who sometimes don't share our same values, and that creates issues. And so conflict is a little bit more robust, a little more common than it used to be. But with the tools we've got, if we use them wisely, I think we're resolving it better than we did 50 years ago. Because all we had was litigation. That's the only thing we were taught in law school. Right. I never heard the word arbitration or mediation once during my law school career. And today it would be rare to find a lawyer practicing, certainly in the construction field, who hasn't been involved in both.
Those are great points.
Yeah.
One last question, since you raised about the tools. So for ADR processes, can those be done remotely then?
Oh, yeah. Most of my mediations are done on Zoom or Teams at this point.
Wow.
Which means we got less people having to travel around. We can get more decision makers who might not otherwise be available to leave the office and travel to show up. It means you could pick a neutral from the other side of the world if you want to, instead if you don't have one in your local neighborhood. So yeah, it made a big difference. It's kept me off of 6 a.m. airplane flights.
That's a definite advantage, I'm sure.
Good reason to put people together. I would say insurance-driven cases probably work just as well on Zoom. Two parties, bet the company kind of disputes, I'd probably like to have them in person.
That's great. Yeah, it does. Well, I think you've made a strong case for the fourth C, paying more attention to contract terms. It's been great having you on, Steve. We'll have to have you back again sometime to chat with us, but thanks for joining us.
Thanks. I'd love to. Appreciate it. Thanks for inviting me.
You've been listening to Let's Get Surety, brought to you by the National Association of Surety Bond Producers. For more information about the NASBP and its members, visit nasbp.org.
Before we go, we just wanted to thank Liberty Mutual Surety again for their generous support in supporting this episode of Let's Get Surety. Liberty Mutual Surety provides contract and commercial bonds for all size companies and contractors around the world. Liberty Mutual is here for you today, tomorrow, together. For more information on Liberty Mutual's breadth of surety products and solutions, visit www.libertymutualsurety.com.